Very good. We have Mr. Tasso and Mr. Elliott in the virtual courtroom. Mr. Tasso, we are ready when you are.
Good morning. May it please the court. My name is John Tasso, and I represent the appellant Florida Gas. I would like to save 5 minutes for rebuttal, please.
Very good.
There are two issues that I'd like to talk about briefly this morning. I'm going to spend just a minute or so on the first one, and then very quickly get to the issue of supplemental proceeding for the breach of contract counterclaim. The district or the circuit court, in its order, provided fees for the easement valuation portion of this case on a lodestar basis. That runs afoul of the plain and unambiguous language of 730921 and the case law interpreting that statute, including, for example, the JEA case. Florida Gas provided a written offer, and you do the math under 730921 under the benefits achieved approach. You take the judgment amount for the easement valuations, you subtract that, or you do the math from the first written offer, and then you apply the statute. There is no basis in the record to conclude that somehow the benefits method is unconstitutional. And there was evidence in the record, including an affidavit from Petrash's counsel, indicating that the fees for those parts of the case, the easement valuation and the breach of contract counterclaim, was divisible. Let's get to the supplemental proceeding issue, because I think that's the more interesting part of the appeal. The second district in the Smith-Built decision indicated that the meaning of the phrase supplemental proceeding is open to some speculation. And what I want to try to do is explain in a very clear way this morning how that speculation can be readily resolved by applying principles of statutory construction. I want to talk about Florida Gas's term sheet that it used and that is the basis for the easement in this matter. Florida Gas, as part of the Phase 8 case proceeding or a pipeline project, obtained literally thousands of parcels across the state of Florida. Most landowners reach a deal with Florida Gas, some don't, and you wind up having to have litigation over that. But fundamentally, the term sheet that becomes the easement in this case is the same. It's not different because Mr. Petrash didn't accept the first written offer. If this court accepts the concept—
So there was no offer with respect to the breach of contract claim, is that right?
There was not.
There was not. And under Smith-Built, doesn't the opinion strongly suggest that when there is no offer that we're supposed to use 73092 sub 2 to calculate the fees?
The only way you get to 730922 in that circumstance is if the breach of contract, a claim seeking construction damages, is a supplemental proceeding. Otherwise, there would have been no reason that Florida—
Let's set aside the issue of supplemental proceeding because of the fact that there was no offer of any kind made. The Smith-Built case talks about a gap in the statute and strongly suggests, although they found a way around it in Smith-Built, that 73092 sub 2 is what should be used when there is no offer, because otherwise, how do you make the computation otherwise?
There's no gap because you have the common law principle that applies. I mean, you have a breach of contract claim where there's no fee provision in the contract. There's not a gap here. If that logic was accepted, literally every dispute under this easement until the end of time winds up being a supplemental proceeding where fees are potentially recoverable.
Let me ask you one more thing about the supplemental proceeding. If there's a question about whether or not that applies in this case, aren't we supposed to look to the notion that the landowner is supposed to be made whole as a result of these eminent domain proceedings?
The answer to that is no, for the following reason. The legislature, the constitutional provision is tied to making sure you're fully compensated for the taking of your property. These are construction damages. These are based on a breach of contract claim. This is not a statute. This is not a constitutional issue. There's no special principles that come into play that would vary applying straightforward statutory construction to what the phrase supplemental proceeding means.
So if I understand correctly, the 30,000 or so odd dollars that would be paid on the valuation claim, that would be the total of the amount of fees that are due and owing?
That would be the total because the only provision that
It
entitles.
seems a little bit hard to swallow, doesn't it? That would be the sum total of the fees after 9 years of litigation and $1 million worth of fees on the other side. Help me out.
So now there are plenty of breach of contract claims that are out there that get litigated where there's no fee provision and then the parties bear their own fees and costs. That is part of the way that breach of contract claims work.
But the fact that this contract was supposed to encompass the restoration of the property back to its original condition, I mean, that sounds a lot like a supplemental proceeding in the vein of what was going on in the Smith-Bilt case, where there was business damages in that case, but it was part and parcel of the whole taking that in order to fully compensate the aggrieved party, 092 subparagraph 2 was employed.
Smith-Bilt is different. It's different because, and two things about Smith-Bilt. First, it's based on business damages, and the Smith-Bilt case recognizes that that's not constitutional, that's statutory. And what we need to do is we need to go to use the principles of statutory construction in getting at 730922. And if we do that, respectfully, Florida Gas submits that there's no way to conclude that the breach of contract counterclaim is a supplemental proceeding. Here's why.
It's a little bit hard to apply statute to the fact that your client promised to restore the property. That's part of the taking. They promised to do that on their own, voluntarily. And so what happens? What does your law firm do? The plaintiff or below, the owner, files a motion to enforce the order of taking. You object to it, say no. It's going to be part of the taking. It's part and parcel of the jury trial. Has to be part of the jury trial. So he tells the judge, no, it's not part of the jury trial. So then he files the counterclaim. When he files that, you move to dismiss. You take legally inconsistent positions all through this litigation to string it out. You tell the judge, yes, it should be part of the jury trial, but then when he files it, no, you move to dismiss. So what's he to do? He's lured in by the legal positions that you staked out in front of this judge. Help me with that.
Certainly. So if we go back to the 73, chapter 73, and what is supposed to be tried in an eminent domain case, it's the
You
value.
said it was supposed to be tried below, and then you took an opposite position when he filed the counterclaim. So tell me why.
Because
Why did you tell the court it should have been tried with the taking and then move to dismiss when he filed it?
what Florida Gas argued is that he could bring a damages claim. The issue is whether you have the same eminent domain jury that's deciding the value of the property interest that are taken, deciding the breach of contract claim. This is not, so let's be, I mean, the breach of contract damages that are sought here, these are construction damages. We cite to the Hillsborough Association case that distinguishes between construction damages and severance damages.
Mr. Tasso, let me ask a question on that, because I agree with you that typically that's the scenario, but the cases that are argued in the briefs talk about what the parties have agreed to do. And in looking at the term sheet, the contract between the parties, it says in paragraph 9 that the full compensation includes all these things. And then it includes within that, as part of the compensation for the permanent easement and the taking and so forth, the repair. So now it seems like the appellant is trying to back out of what it represented as part of the contract. So why am I wrong in reading it that way?
There are the amount of money that's changing hands for the property interest taken are different than the provisions that detail how the party's relationship is going to be handled over the years. Respectfully, that provision on restoration is no different than other provisions in there about what the landowner in Florida Gas can or cannot do 5 years down the road, 10 years down the road, 15
So
years.
is it your position, just looking at paragraph 12, which says, during construction, Florida Gas will bury the pipeline to a certain depth. Is it your position that if Florida Gas failed to do so, your position is that cannot be part of the taking compensation, right?
That would not be part of the taking. Those are construction damages.
even though paragraph 9 talks about the full compensation to be paid in relation to the taking, and it includes repair items.
So what has been taken here? And I want to go back to that. There's the easement that was taken, and then there's no severance damages. There's only 2 buckets here that could be takings damages. That's it.
Doesn't the case law basically say if the party that is doing the taking agrees as part of its contract to do certain additional things as part of the taking process, that in effect is part of the taking and is compensable as part of the taking?
The case law emphatically does not say that. There is no case law that says that a breach of contract claim for an easement, that is a supplemental proceeding under 730922. It's not there. And if the court goes back to basic statutory construction, let's do statutory construction. 730922, the associated words canon. Is this have anything to do with defeating an order of taking or an apportionment? No, it hasn't. And then you have the legislative history that we cite to that indicates that this is a narrow exception to the benefits achieved approach in 730921.
So you're arguing a promise to restore the property to its original contour and condition has nothing to do with the taking.
It has nothing to do with the taking.
Original contour and condition.
It's not a taking issue. And how do we know that? We know it because Mr. Petrash in his counterclaim expressly states that the counterclaim does not rise from the taking itself, but has to do with the events that happened in construction after the taking was done. Now, this court, Petrash sought severance damages at the trial court level. The court excluded those damages, and then Mr. Petrash went up on appeal. It is law of the case that Mr. Petrash has no severance damages here. Why am I bringing that up? Because if you use the whole text canon to get at what 730922 means, then what you do is you look to chapter 73 and you look at what damages are recoverable in eminent domain. You have the value of the property interest taken, and then you have severance damages. And by this court having affirmed the trial court and saying that there's no severance damages, you're left literally with a construction bucket for damages. And the promises that Judge, that you referred to, that's no fundamentally different than any other promise that's in a contract that does not have a prevailing party provision. And so if you have the legislative history that says this is a narrow exception, there's no way this is a narrow exception if from now until the end of time, if there's ever a dispute under this easement, that all of a sudden we're going to come in, whether it's Mr. Petrash or his heirs, we're going to say that therefore this is a supplemental proceeding under the eminent domain statute because the interest would never have been acquired but for Florida Gas exercising its rights under eminent domain.
Mr. Tasso, you said there were no cases that support the position of the appellee on this issue. So would we, I'm not sure I agree with you on that, and I'm sure Mr. Elegant will be addressing it, but assuming the Shaw case, for example, supports the appellee's argument, would we be in conflict with Shaw to adopt your position?
You would not. Shaw is pre-730922. It's not interpreting what supplemental proceeding means. Shaw is also a fight over the bucket.
Shaw does address damages arising from the taking that arguably would be contract type damages under your argument, but they treat it as part of the taking.
That respectfully in Shaw, that's part of the monetary offer for the take that that was proposed by the condemning authority up front. That's not materially different than an apportionment proceeding, a post-judgment proceeding where you're fighting over how the monies for the taking are compensated. Let me deal with a couple of other points quickly. Section 44103 doesn't apply to the counterclaim. It doesn't apply because Florida Gas never asked for a trial de novo on the counterclaim. And under the McHenry decision of the Supreme Court of Florida, there's no way to square the specific language of the eminent domain statute 730921. There's no way to square that with awarding fees under 44-103. The court is required to give effect to the word solely. And then on Mesemer, we would have relied fundamentally on our briefing, but when you have an expert whose opinion was excluded on several points, it's error and an abuse of discretion under the Miami-Dade County case that we cite to award the expert expenses. Unless there's
Tasso, you've used up 15 minutes. If you wish to reserve the rest for rebuttal.
yes, please.
Very good. Thank you.
Sure.
Mr. Elliott? Mr. Elliott, before you jump into your argument, I do want to ask you the same question. If we were to adopt the appellant's position in this, would we be in conflict with Shaw?
Probably, and certainly in conflict with the court's own decision in M&C and in conflict with the Florida Supreme Court's decision in Kendry. So there'd be a lot of conflict, in my view. And I'm happy to go into that in more detail. I think the first issue in the case is Florida Gas's, and it's already anticipated by the questions that have come before, but is Florida Gas's obligation to restore part of the eminent domain order. And I would submit it is. If you look at the merits record at 102 and 104, it says Florida Gas is entitled to the property in the attached Schedule 1. Schedule 1 then at 109 includes the promise to restore. And then when you get to Exhibit A to Schedule 1 is the legal description of Mr. Petrus's property. Florida Gas violated the eminent domain order. It's not just a breach of contract. In fact, it's not a breach of contract. There's no common law or negotiated contract here. Page 2 of the initial brief, Florida Gas says Mr. Petrus did not accept Florida Gas's offer. If he had accepted the offer, they would have given a deed, then there'd be a contract. This was not a contract. This was a taking order. And everything that followed from it then was a breach by Florida Gas of the taking order. The taking order required them to do this. And they took his property by eminent domain. I won't go through the numbers. You've already done that in the earlier question, but it's supposed to be a level playing field, not dog eat dog. This was a breach of an easement. The Kendry Florida Supreme Court case says a breach of an easement is a taking. That case is not discussed in either of Florida Gas's briefs. I would suggest because there's no way to distinguish it. The easement that we're talking about appears in the order of taking. This court in the M&C case, when it enforced a contract promise or said the party could seek to sue to enforce the contract promise after the construction, when they had damaged the pool because they had promised they would restore it, the court describes that as in this eminent domain action. Or in this eminent domain proceeding, it's part of the same proceeding. Mr. Petrus should have been permitted to proceed as an inverse claim under Kendry and Mobile Gas, simply because Judge Foster, who came in for one hearing, labeled it a contract claim, does not eliminate Mr. Petrus's right to full compensation. It is an inverse claim, in effect, and an inverse claim is a Section 2 fee. There's really no dispute about that. Now, once we, and I'll talk about the arbitration in a minute, because we do think that applies. Once we get to where there's anything more than 30 grand that he's entitled to, we recognize that either under Section 2 or arbitration or any other theory, I would respectfully submit we're done. Because the only relief that Florida Gas asked for below, when it got to the final hearing and on appeal, is 30 grand. The April 2020 stipulation by Florida Gas says if the lodestar applies, then the $627,000 fee is reasonable. Well, less than the 1.1 million, but 627,000. So they'd say, oh, we're reserving all our arguments. We want to argue about this and argue it should be, it's no Section 2. That's fine. They can reserve the arguments all they want, but they never asked the trial court to make any other findings, to apportion anything, to say, well, if you agree with us and there's no arbitration, then reduce it by this much. If you agree with us that there's no fee for the enforcing the order of taking, then you've got to reduce it by this much. They never asked the trial court to apportion. For their point of view, it's 30,000 or nothing. 30,000 or that's the only relief they request. And I would suggest that's why on appeal, that's the only relief they ask for, is limit the fee to $30,000. So all these objections or arguments that they say they preserved, they may have preserved arguments, but they've waived any relief by not asking to do anything other than 30 grand. Once the order came out, the judgment came out, there was no rehearing request, no motion to apportion. Judge Sleet, it's like the original trial where they didn't ask the jury to separate this out. And I know you made a point of that in the prior oral argument. We have the same situation here, a lack of preservation by Florida Gas.
Well, let me ask you this, Mr. Delegate, because it appears, I mean, there's two verdicts for the taking and the breach of contract. So we have two separate numbers.
Right.
Could we not apply subsection 1 to the taking award and subsection 2 to the breach of contract?
Your Honor, I think if we did that, we would just add 30 grand onto this result.
Because it appears the court just lumped it together and then applied the lodestar to both, when the statute's clear about a taking award.
Well, Your Honor, what in the context of this, the April 2020 stipulation between Florida Gas and Mr. Petrus counsel is done the morning of the hearing. I mean, that's when it's put into court, and that and they say 627 is the appropriate lodestar fee. I don't think anybody disputes that you can do the math on the 220 and come up with 30 grand and change. I think the only question would be, should you add the 30 grand to the 627? The trial court didn't do that, and we're not asking for that. So I think you could say that the 30 grand is encompassed within the 627. I mean, the 627,000, when you look at the hours that were cut and the agreements that were made to reduce that, it's a modest fee. I don't think there's any dispute about that. I think that's why they didn't go back and just say, we want to parcel this out and we want it to be less if it's this and that. And again, getting back to calling this a contract, I don't think you can deny constitutionally mandated fees by a label. They want to put a label on it and say it's a contract. Now they say, oh, well, what if we have to come back and repair something years later? Well, that's not this case. That's another issue for another day. Personally, it doesn't offend me that that they need to maintain their pipeline. It's on somebody's property. They need to come back out and fix it. And if they don't want to do it and they get sued, the landowner shouldn't be out that money. But that's not today's issue. Moving to the arbitration fee. And again, I guess take a step back in terms of the construction and how we look at this. And we've pointed this out, I think, at page 20 of our answer brief, but the overriding principle in construing eminent domain statutes is to construe it in favor of the landowner. That overrides everything else. So they want to say, well, 44 is, they want to say, well, we have specific eminent domain fee statutes. That is true. There are two of them in 73.092, two parts. There's a separate proposal for settlement statute. There's a separate appellate fee statute. There's only one arbitration fee statute. And it applies here. It's the only, and they say, well, there was a legislature made a proposal for settlement fee statute in Chapter 73. Yeah, they did. And that one controls. They didn't make a separate arbitration fee statute in 73. At a minimum, one would have to look at the arbitration that Mr. Petrus was forced to go through as a supplemental proceeding. It's part and parcel of the eminent domain thing. As everybody noted, it's unusual to have arbitration in eminent domain. So why is that not a supplemental proceeding? It is. It's something additional. It's supplemental. And so for that, you would at minimum get a lodestar fee. And since there's been no request to this court or to the trial court to apportion things, we're above 30,000. We're done. The other thing on the arbitration is viewing it as a whole. They say, well, they said Florida Gas didn't demand it on this, and Petrus demanded it on that. Between the two of them, they demanded a new trial on everything. And that's what happened. So if you look at this as a total, which is what Judge Cook said, if you look at the fee order, or excuse me, the fee record at like 1638 and 1640, you'll see her saying, this is a whole. You know, you can't, it's all overlapping and you can't break it out. When you look at it that way, the 113 plus 43, which was the arbitration award, is 156. The $700,000 plus verdict is way more than 125%. So under that theory, we also trigger the arbitration fee provision. And again, once we're over 30 grand, I respectfully submit we're done. As far as Mr. Meismer goes, this court's opinion in Burdett says the trial court has discretion to award a fee when the expert doesn't testify. As we detailed in our answer brief, Mr. Meismer covered lots of territory that other experts used. The statement that he was not used is simply not accurate. Florida Gas had different experts. Did it not pay all of its? Did it say, oh, you didn't testify, I'm not paying you? It changed experts and so forth. The owner's supposed to be on the same footing. This is an abuse of discretion call. There was no abuse of discretion here. I'd ask the court if there are any further questions. If not, we would ask that you affirm. Thank you.
Okay. Thank you, Mr. Elegant. And counsel, you've got your 5 minutes of rebuttal time.
Thank you. Let me start with the fees for the easement valuation part of the case, because I think that's straightforward. Chapter 73, 730921 says that the way you calculate fees is based on the benefits approach. And the only argument that I heard from counsel a moment ago are two. There's a claim that somehow Florida Gas didn't preserve that, which I'm going to talk about. And then there's a claim that somehow these fee amounts are they're indivisible. On the preservation issue, that's simply wrong. What happens is that Florida Gas, at the time of the summary judgment hearing, and then later on at the hearing in April of 2020, points out to the court, hold on, you can't just come in and say that there's these fees for breach of contract and for the easement valuation are indivisible, because Mr. Petrash's own lawyer has signed an affidavit indicating what the fees were for the takings portion and for the breach of contract portion. So, and he's stuck with his affidavit. There's no way for the circuit court to come in now and say that somehow you can't divide this out when Petrash's own counsel did so under oath. And then in the footnote 1 to the stipulated judgment that Mr. Petrash's counsel talked about a moment ago, Florida Gas expressly says that it is preserving any and all objections to the summary judgment order. And that part and parcel of that was Judge Cook's finding that wasn't supported by anything in the record. I mean, she doesn't cite to anything, that she can't figure out what portion of the fees relate to breach of contract and which part relates to the easement valuation.
So, Mr. Tasso, if we take this argument as correct on your part, that still just means there's a difference in the computation of about $28,000. If we apply the Lodestar method, I think he testified to 146.4 hours on the valuation at $400 an hour. That's $58,560. And under subparagraph 1, the benefits method, the fee would be $30,200. So in the overall scheme of things, we're not talking about a significant amount, even if you're correct. I mean, the guts of this case really lies in how you handle the restoration issue.
Respectfully, that's not accurate. It's not, because Mr. Petrash's affidavit, where he breaks out the time for the taking and the breach of contract, over half of his time is in the easement valuation part. The only way that the number that Your Honor referred to a moment ago applies is if Mr. Petrash prevails in arguing that 44103, the non-binding arbitration, also gives him fees for the taking portion after the arbitration. And you can't get there based on the McKendry decision from the Supreme Court, because here you have an eminent domain statute that is specific to eminent domain that says that the award for fees for the valuation is solely based on benefits achieved. There's no place to apply a general non-binding arbitration statute to get him his fees. So that assumption is not accurate. let's talk about the case law that Mr. Elegant says shows that he's right, and that this is the breach of contract is a supplemental proceeding. M&C, it's not a supplemental proceeding case. It involved a situation where the parties agreed in a settlement agreement about the court reserving jurisdiction on certain things. And Mr. Elegant is relying literally on docket entries that this court awarded fees to make an argument that somehow that's a supplemental proceeding case. It's not. I heard him mention the Kendry case. I asked the court to go look at the Kendry case. Kendry is an inverse condemnation case. It's supplemental proceeding, and it says that there shouldn't have been a motion to dismiss granted. Kendry is not what was gone to trial on here. Mr. Petrash made the decision to go to trial on a breach of contract claim, not an inverse claim. That's what went up on appeal in the merits case. The idea that somehow this is not a contract is completely contrary to Florida law. I mean, not all if you have a taking and you wind up with an easement that's acquired, you're going to apply contract principles interpreting that as the years go on.
Mr. Tasso, you're just about at the end of your time. Take about 10 seconds to wrap up.
So again, on the supplemental proceeding issue, ask the court to apply the law on statutory construction because it hasn't done it yet. And if you use the canons of construction, this is not a supplemental proceeding. Unless the court has any other questions, appreciate your time this morning.
Very good. Thank you, Mr. Tasso. Mr. Elegant, that concludes the presentation on that case.